Hello. The topic of this video is civil liberties. Civil liberties is discussed in your book, so please read the assigned chapter before attempting any written questions about it. But I do want to talk a little bit about what civil liberties are and what it means. So civil liberties are the constitutional rights that are guaranteed to all Americans. You can find them in the first 10 amendments to the U.S. Constitution. So the original Constitution, written in 1787, did not contain a Bill of Rights. The framers of the Constitution, the men who wrote it, did not think it was necessary to include a Bill of Rights because they thought that the Constitution would already limited governmental power enough. But it was quite clear that there needed to be specific limitations on what the government could do in terms of people's individual rights. So as soon as the Constitution went into effect, Congress adopted the Bill of Rights as amendments, and they were ratified by the states. In the video, I just want to talk about a couple of those rights. The First Amendment rights are the ones that we often hear about. The First Amendment guarantees our right of freedom of religion, freedom of the press, the freedom of speech, which is a very important one. In terms of freedom of speech, it basically means that we are allowed to say what we believe without fear of being restricted by the government. And we can criticize political leaders, we can express our opinion about political issues, or almost anything we want. However, we are not allowed to endanger other people. So, for example, I could say that I disagree with the president on something, but I would not be within my rights to threaten the president physically in any way. So that's an example of a limitation on freedom of speech. But freedom of speech is broadly protected by the First Amendment and through Supreme Court decisions, as you'll read in the book. The Supreme Court over a period of time has given maximum protection to that right so that people can express their views freely without censorship and without being told they can't say something. I should also mention, with regard to freedom of speech, it does not give someone the right to lie about another person. However, lying is not usually something that's punished in any way unless the person who's lying has defamed someone else's character, libel or slander, which are discussed in the reading. So if you spread a lie about someone with the intention of harming their reputation, and it actually has that impact, and it can be demonstrated that you did that on purpose, you could be punished for that. Now, that usually would apply mainly to people in the public eye. So a political leader might try to sue for libel or slander when their opponent says something false about them. However, the courts have made it very difficult for elected officials, people like the president or a governor or a mayor or a celebrity, to sue for libel or slander, because the expectation is that people are going to say things about them, and the courts did not want to make it easy for political leaders to sue for things like that, because then the media would just stop reporting altogether. So a president or a major leader usually is not going to win a libel or slander lawsuit. And they just have to expect that people will say things about them. The authors of your book also talk about symbolic speech and other forms of expression and the limits on them, so make sure you read through that. Freedom of religion is the right to practice your religion freely without interference. It also means the government cannot establish a religion for the nation, so that's known as the Establishment Clause. So free exercise and establishment are important things. However, with regard to freedom of religion, you cannot endanger another person with your religious practice, so that's a limitation on it. And in terms of establishment, the government, while people might, for example, get a bus ride to their parochial or private school, the government will not provide assistance to them for tuition or provide religion books for use in the private school. So there are limitations. With regard to the other amendments that are part of the Bill of Rights, you have, for example, the ones that guarantee due process. Due process is the right of a person to be you're assumed to be innocent unless proven guilty by a court of law, and there are rights that are designed that are in the Bill of Rights to guarantee those freedoms. So, for example, the government must provide you with a lawyer if you cannot afford one. That's the Sixth Amendment right to counsel. The government cannot try you twice for the same crime. That's the double jeopardy part of the Fifth Amendment. So, for example, if you are found not guilty in a court of law, the government cannot appeal that verdict. They have one chance to prove their case, and if they can't prove it, you are innocent and you are free to go. There's also freedom from unreasonable searches and seizures. That's why the law enforcement must have a search warrant to search your home for evidence of a crime. They can't just come into your home and start looking through things. There's also the prohibition against cruel and unusual punishment. So if you are found guilty, the sentence has to match the crime. So you would not put somebody in jail for 30 years for a minor crime. Now, we all know situations where these rights have not been protected, and that is one of the ongoing issues in this country, and certainly racial disparities in terms of sentences that are imposed on people, and for example, the differences between crack cocaine and powder cocaine, or how people are treated at traffic stops, things like that, which have been very much in the news. But the basic protections of civil liberties, all of the amendments do extend to all of us. I should mention that originally they only applied to the federal government, meaning that the federal government was not allowed to deprive you of these rights. They did not originally apply at the state level because the men who wrote them didn't think that states would take away people's rights. But we know very clearly that states have taken away people's rights, and that it's very important that the Bill of Rights be protected, not just at the federal level, but at the state level. Probably more important that they're at the state level, because that's where most of the laws we have to follow are state laws. So almost any time someone's in court for any issue, it's going to be in a state court, most likely not in a federal court. There aren't that many federal crimes, and there aren't that many times when people have to go into a federal courtroom. So it's very important that these rights be extended to the states. The amendment that has allowed the Bill of Rights to be extended to the states is the 14th. The 14th is discussed in detail in your reading, so please make sure you read through that. But the 14th Amendment guarantees due process of law at the state level, and so that provision of the 14th Amendment has been used to incorporate the Bill of Rights so that they can be applied at the state level. And there's a discussion of incorporation in the reading, so make sure you read through that. So I just want to give you a little background about civil liberties. They are very important limitations on the power of both the federal government and the states. And whether it's talking about the First Amendment freedoms or the rights that we have when we're accused of a crime, due process rights, or other ones that are mentioned in the Bill of Rights, they're all very important, and the courts must follow them. One last thing I'll say is that if somebody's involved in a criminal case, so if somebody has been found guilty in a criminal case of committing a crime, the issue of their rights could be a reason for appealing. So, for example, if someone was found guilty in a trial, but there was evidence used against them at that trial that should not have been used, then that could be the grounds for their appeal. The defendant could argue, the convicted defendant could argue, that the judge should not have allowed certain evidence to be used at trial because it was not taken with a proper search warrant, which would violate the Fourth Amendment, freedom from unreasonable searches and seizures. So that could be the grounds for an appeal. So a lot of times these rights are used in appeals, and that's why trial court judges really need to be very careful to protect these rights. Otherwise, their verdicts could be overturned at a later point. So, all right, I hope that makes sense. If you have any questions, please email me, and hope you have a good week. Thanks.